My name is Matiss Krumins. I'm one of the barristers in the public law family team at 3PB, and I'm joined today by Esther Lieu, and we're both going to give you two talks. Mine's going to be a rather broad topic of judicial review and human rights, and Esther's going to be dealing with financial remedies case law review. I'm going to be first, and Esther's going to follow on from me, and then there will be an opportunity to ask questions, and we'll do our best to answer. I anticipate both talks are relatively long, um, and so we're going to be a bit pressed for time. So we'll do our best with questions. There's a question and answer box within Zoom. If you put your questions in that, we'll be able to review them and have a chance at answering them if we've got time. The slides will be available to you afterwards. I've got quite a number of slides to cover, so please don't worry if I'm moving through them. You will get a copy of them to deal with. So I'm going to get straight into it, and it's in respect of judicial review, human rights, and within the context of family proceedings. It's an area of work I deal with. I do both judicial reviews for and against local authorities and Human Rights Act claims for and against local authorities, all within the context of matters that relate to children. So today we're going to cover, I'm going to do an overview of judicial review, overview of human rights, and its application to family proceedings. These are going to be quite broad overviews of what are both very technical areas of law. The intention is this is a foundational part talk, and I'll be coming back on the brunch to do further more in-depth points. If there's anything that anyone wants to have covered in particular, by all means, I'm open to suggestions for another talk to follow up on any of these points. So I'm going to start with judicial review. Basically, judicial review is a process by which a court exercises supervisory jurisdiction of public bodies. You can remember it's not a right of appeal, and we're going to look at the very basic elements of the relevant principles, because once you understand those, you can see the context in which they apply to family proceedings. What you do have to remember, the civil application, CPR 54 applies, gives you a definition of what judicial review is. It's a claim for judicial review is to review the lawfulness of an enactment or a decision, action, or failure to act in relation to the exercise of a public function. You're more than likely going to be dealing with the latter part. It's rare that you'll be challenging an act of Parliament as either under JR grounds. I'm not saying that's impossible, but most claims that I deal with are in respect of the second matter. Proceedings are almost always in the Administrative Court, King's Bench Division of the High Court. I'm going to caveat that in family proceedings, there could always be an opportunity to bring a judicial review because many of the High Court judges have jurisdiction in both the family court and the administrative court, so they could sit and hear both matters. One thing you do have to remember with judicial review is, and this is, I'm going to give a caveat to it, is that you traditionally don't enter into an analysis of substantive merits of a decision. What you're looking at is whether the decision that was made was lawful, procedurally fair and rational. However, there have been, and there are quite a few exceptions to that. Human rights, in fact, is one of them where the court may go into looking at substantive merits. Again, it's a complex issue, and I'm skimming over some of these points. They are just something to bear in mind. Traditionally, you don't look at the merits of a decision. What you're looking at is the process in which the decision was made. The proceedings are complex, and there's a very important pre-action procedure that must be followed, even if you're doing it on short notice. You'll be dealing with two stages of any proceedings. There's a permission stage and a full hearing. I'm not going to cover those stages in detail. It's just so that you know that there is a process. There's a pre-action process, and there's a permission stage process, and then there's a full hearing process. Most judicial reviews will be dealt with within two hearings, if not less. Permission can be dealt with on the papers, and then it can be dealt with at a hearing, and then you'll have a full hearing. You'll rarely have case management hearings. It will be a case of file all your documents, file all your evidence, You'll have a defence and a response from the public body, and then the court will hear the matter. So understanding who can be challenged is perhaps the beginning point of judicial review. You need to understand that the defendant has to be a public body, or there has to be sufficient public element of it. Again, I'm not going to get into the details as to the definitions here. I will cover broadly what public bodies are. And then what you're looking at is a decision, an act or omission that is public in nature. So public bodies that we'll be dealing with, there are obviously public bodies, government departments, local authorities, county courts, ombudsman, governing bodies of maintained schools, police, they're all public bodies. And so their decisions generally are amenable to judicial review. The decision that can be, so you have a public body, it always has to make a decision that can be challenged. That decision has to have a public element to it. So it's relatively straightforward. Generally, you'll find the decisions you're challenging are public because they're decisions that affect a person who's using them. Easiest example perhaps is, for example, disabled children. Disabled children will be accessing a local authority's disabled children's service and seeking help with support, and there might be a challenge to the support plan, and a decision made in respect to the support plan is amenable to challenge by way of judicial review. Public bodies can equally make decisions that are not capable of being challenged. For example, hiring a new member of staff in a particular team is generally considered a private decision. That's not always. There are caveats to all of these points, but you have to bear in mind, is it a public decision? Generally, if you're going to be, for example, I gave you a service user, that decision is made in respect of, then you're likely to be falling quite clearly in a category of what's called a public decision. And then, of course, I've gone almost back to front, but you need to have a public body who makes a decision, and then, of course, it has to be who can bring the claim. There's a broad definition in judicial review. That's a matter of some ongoing debate as to how broad that is, but it is broad, and it's anyone who has a sufficient interest to which the application relates. That is determined on a case-by-case, fact-by-fact basis. My general view is if someone is affected or impacted by the decision that's been made, they're likely to be in a position to bring a claim. So there's a caveat. It's not anyone from the street can bring a claim against a decision they don't think is very good. But if it's a decision that impacts them or affects them in some way, then it's likely they can establish locus to bring a claim. So those are the elements that you need in order to establish whether or not you can bring a judicial review. A brief reminder is that judicial review is often called a remedy of last resort. You will need to bring it if there's no other remedy available. So you will have to have gone through any statutory appeal processes, any appropriate complaint processes. Equally, the remedy that is or said to be available has to be an effective remedy. And so judicial review is not generally an optional remedy. It's a remedy where you have no other options left, where the decision has been had, there's been a meeting, there's been challenge, there's been discussion, there might have been complaints made about that, and then you're at the point of making it. But don't put it on the slide. There is a time limit. You have to make an application for judicial review within 3 months of the decision that's been made. And then we turn to what are the grounds. And again, I'm doing an overview of these grounds. And there is some complexity in them. But these are the bases. And the whole purpose of this is so that it can assist anyone who's as part of this is being able to understand these are decisions that are capable of being judicial review. This is something to be looked at, and it may be something that you want to seek more specialist advice in respect of. So there are multiple grounds you can bring a judicial review on. Perhaps one of the easiest is illegality or error of law, and that's effectively the public body has either applied or misapplied a legal test, or not followed a particular enactment of law, or made an error in respect of it. That equally applies to published policies. There's an expectation that public bodies will follow policies, that there will be published policies in respect of various decisions they have to make. One of the critical aspects of any policy, however, is that they cannot adopt an inflexible policy. So generally you'll find now is that most policies have a discretionary clause which allows them to make decisions outside of the policy, outside of the particular guidance that they've set in respect of making decisions, so that they can deal with unusual circumstances or fact-specific issues. One of the other grounds of claim is material consideration, and it's basically, has the decision maker taken something into account they should not have, or have they failed to take into account something they should have when making the decision? I think that's a relatively straightforward one. Your claim is factually based. Is it, have they considered something or haven't they considered something? Another ground, mistake of fact. I think that's relatively straightforward. They've made a mistake as to a fact that is either relevant, or they've taken, it might be, as per the previous one, taken into account an irrelevant fact. Proportionality. Now, proportionality is a much more complicated claim. I'm going to talk a bit about it with Human Rights Act matters, because that's when you generally start dealing with it. The question becomes, is the interference with something, generally a human right, proportionate to the legitimate aim in respect of it? Those are, I'm going to suggest, quite complicated matters, but something to bear in mind. Irrationality. Now, this may be the one that everyone remembers from the public law classes. This is also known as Wensbury unreasonableness. It is one of the harder ones to establish, because you need to establish that no other reasonable person could have reached this decision. I think that's quite a complicated issue to do, because the bar is set relatively high, and it's there to challenge decisions that are just blatantly wrong decisions that have been made by public bodies. And the other ground is procedural unfairness and impropriety. Again, this ties into human rights, Article 6, fair process. A decision needs to be made in a procedurally fair way. So it's often what will be referred to as natural justice. Straightforward idea is that if they have a policy or a procedure that's set out in how they make the decision, you'd expect that policy and procedure to be followed. Effectively, you'll be looking at Article 6 rights, so you'll be ensuring that there is a right to be heard and there's an absence of bias. There's generally an expectation for there to be reasons provided for any decision to be made. There can be arguments in this area around legitimate expectation. So these are all, as I said, covered quite a lot in a short period of time, but it gives you an idea of these are all the grounds you'll be looking at in order to consider whether there is a valid judicial review claim. And I'll come to its applicability towards the end of all these, because it does come up quite a bit more than people realise. Very quickly, in terms of remedies, they are to some degree limited, but effectively the court can set aside a decision that's been made and order the public body to remake it, require them to do something, stop them from doing something. You can have interim decisions. You can get interim relief to protect a position, to stop an alleged harm occurring from decisions. There's also declarations that can be made, as well as damages and restitution. But generally, just think about it in terms of you can stop something happening, you can make someone do something, or generally the order will be requiring the public body to remake it. So that is a very quick 15-minute overview of judicial review. By all means, you can ask questions about it. It's to give you a primer as to understanding the basics of what you're looking at in public law decision making. And then I'm going to turn to human rights. Human rights, there's an overlap between these matters, as you've already seen me talk about it. But human rights are fundamental rights that we all have, that the UK agreed to as part of the European Convention of Human Rights, and that fundamentally the Human Rights Act incorporated all those into domestic legislation. So Section 6 of the Human Rights Act makes it unlawful for a public authority to act in a way which is incompatible with convention right. That requirement, in fact, I'll turn back to that now. So we'll just establish some basics. Again, the question arises, what is a public authority? Generally, for our purposes, a local authority, the court, the police are all public authorities. There's a very difficult and complex consideration as to whether other organisations are public authorities. It will depend on the function they're exercising, whether that's public function. So it can be fact specific, that can be a statutory function, it could be a delegated function, it could be any of these matters. So that certainly is where it gets a bit more complicated. But for us, certainly most often it's going to be a local authority, the court and the police. In terms of making a claim pursuant to the Human Rights Act, that's a difference to the judicial review. Judicial review has a much broader test. The claim for human rights is a claim can be brought by a person who says that the public authority has acted in breach of their convention rights. The claim can be brought in two ways. You can either bring it within current legal proceedings. So that may well be within family law proceedings that you're dealing with. So you can raise a separate claim, but it has to be by way of claim form. It is insufficient when you're asserting significant breach and seeking remedy to simply raise it, for example, at a final hearing. You can rely on rights, but you can't raise a claim against the local authority because you have to make a claim for it. There has to be a response, and then consideration as to evidence to prove either side of it. Alternatively, you can issue a freestanding claim, which is a civil claim within the following civil proceedings, Part 8 claim against a local authority or the public body to bring a claim for an infringement of human rights and restitution for the same. I'm going to do an overview of those rights. Again, I'm very sorry, it's going to be rather quick because of the time we have for this. I'm going to deal with the rights that come up most commonly in the practice that I deal with in terms of children and family law. One of the most fundamental rights is Article 3, which is prohibition of torture or to inhumane or degrading treatment or punishment. I've given you the definitions for torture, inhuman treatment and degrading treatment. Torture is incredibly rare. Inhuman treatment, degrading treatment are claims that are often made. One thing to remember is that one of the arguments I have is about destitution. Destitution of a child does fall within Article 3. And so if a child is, for example, street homeless and destitute, and a local authority fails to act, that is generally considered to be an infringement of Article 3. One thing to remember in respect of inhuman treatment, degrading treatment, it isn't about hurt feelings. It is a minimum level of severity, and the UK has set that as a very high level. Generally, you'll see claims here where it's been multiple years of neglect, multiple years of failure to take action that resulted in very significant harm to children. Just to continue on Article 3, there are two duties to be very much aware of. There's the negative duty, which is absolute. This one is not commonly an issue, but this is where the local authority itself treats someone in a way which infringes Article 3. The more common claims are within the positive duty. There's a positive duty on local authority to take reasonable action in the circumstances to protect people from harm that others may do to them. That prevention can extend to chronic neglect and abuse cases for children. And so what you'll often see is public law family proceedings where there's been multi-year failure in respective cases, and you'll have papers disclosed to specialist solicitors for making claims on behalf of children. Article 5. Article 5 is your right to liberty and security. That comes up quite often in respect of older children. People will become much more familiar with this as terms of deprivation of liberty, and effectively it's your right against unlawful detention, arrest. Dole's courts have now been established. These claims are not common, but they are important things to remember, that the dole is to effectively legitimise an infringement of Article 5, or to prevent an unlawful infringement of an Article 5 situation. So everyone is entitled, including children, to a right to their liberty and security. And so Article 5 claims relate to that. Article 6 claims, they're going to be matters that people are commonly dealing with. So there's the right to a fair trial. You will often have arguments in family law claims in respect of this. This is actually a very complicated right, because you're entitled to a fair and public hearing within a reasonable time by an impartial tribunal. What you have to remember is that the right to a fair trial itself is absolute, but the right to the constituent parts of it may be limited. And so and of course the limitation has to be proportionate. So those rights could be access to a court which is real and effective, independent, impartial tribunal. In public, we don't do hearings in public generally when they involve children. So that's an example of where the right's limited. Has to be dealt with in a reasonable time. There has to be a real opportunity to present a case at an oral hearing if required. So you have to remember there isn't an automatic right that everything's heard at an oral hearing. All of these rights are caveated. The right is fact specific to the circumstances and as to what is fair in those circumstances. And so its application can become very complicated in respect of dealing with these matters. Article 8 is one that I think everyone is going to be familiar with. That is the right that is most often dealt with by family cases, because it's when you have a family case, you're almost certainly engaging Article 8. And so the questions then become, is the infringement of someone's Article 8 rights necessary and proportionate? Because this is a qualified right. So interference can be justified if it is necessary and proportionate. It is, I'm going to suggest, an exceptionally broad right. There is generally a need to demonstrate either a family life or a private life. These have all been given incredibly broad definitions, both by the UK courts and by the European Court. In terms of making an application, time limits. Time limits are something that are a huge problem, because you have to bring the application within a year from the act complained of, or that time limit can be extended if the court considers it equitable. You have to remember there is no provision, as there are, for example, in negligence claims, for a child or an individual who's under 18. The time limit applies. And so one of the things that people fall foul of, particularly when they're representing children, is if you're in protracted proceedings where there may be an allegation of an infringement, that you are duty bound to deal with that, or at least get a moratorium for the time limit to prevent the time from expiring for a child you're acting for. That is a common issue that comes up in the claims I deal with. As I set out, there's a Part 8 process, or you can deal with an application within proceedings. Remedies, I'm going to have to be very quick about because I'm running out of time. Your principal remedy is a declaration, i.e. that the public body has unlawfully infringed individual rights. If the court deems that remedy to be insufficient in the circumstances, you can claim damages for it. General experience is where there have been significant infringements of children's rights or family rights within family proceedings by public bodies, damages have been applicable, and there's quite a lot of case law in respect of that. Equally, there can be legislation that's incompatible with human rights. I'm going to suggest, I'm not going to cover that in detail. That's a rare situation, and it's very rare and it's very complicated. That will generally be a case that either is dealt with at a high court level, or in fact can be immediately leapfrogged to Court of Appeal, Supreme Court to deal with where there are such claims. So just to cover common areas where judicial review may be applicable. For example, which aren't within the family court remit, be it public or private law, decisions of fostering decision makers, services to be provided to disabled children, provision of support and accommodation to a family. All these are matters that the local authority has powers to make decisions over. If it is making a decision in respect of an individual and it is a local authority, that decision is amenable to judicial review. Something to bear in mind when you have decisions that seem negative or in some way wrong, they may be amenable to challenge. Of course, you have to go back and look at all the grounds for it. Just because you disagree with it doesn't mean it's an unlawful or irrational or unreasonable decision made by a local authority. In human rights, common claims are Article 6, Article 5, Article 3. I've covered those issues. Article 6, you may have a claim, for example, where a judge refuses to listen to arguments. We'll have seen, I think, now several cases where which have been reported where judges have refused to listen to arguments. Article 5 is often coming up in deprivation of liberty. Those are now formalised with the Dole's Court and dealt with. Article 3 is an area of ongoing significant contention as to where a local authority fails to act to protect a child, because there are multiple Supreme Court decisions in respect of it, but it is something that comes up. So thank you everyone for listening. That has been quite a pace and quite a lot for me to cover. If you have any questions, I will deal with them after Esther's talk, and I'm going to hand over to Esther now.
Good morning, everybody. Hopefully you can see my slide. I'm sure someone will alert me if you can't. And thank you to Matiss for that talk. Similarly, I have quite a lot to cover. I will try to get through it at a pace, but without rushing, and my notes will be available after the talk as well, if you want to refer back to them. My intention is to go through a handful of recently reported cases, trying to focus on how they help us in practice. And of course, given the title of this talk, it would be amiss not to start with the recent decision of His Honour Judge Hess that was handed down in May this year following a 4-day final hearing. The facts are relatively straightforward. Both parties were in their 40s, the marriage of 9 years, to include 5 years of cohabitation. They had 3 children under the age of 10, and their assets held in their joint or sole names at the time of trial came to around 9 million. The issues in dispute were essentially the husband's case, that various assets in his name were non-matrimonial, and the husband's case that the court did not have jurisdiction to make a child periodical payments order as sought by the wife. Addressing the question of non-matrimonial property first, the only area of agreement between the parties was that the husband's 50% interest in his father's home should be excluded. The court then proceeded to exclude a sum of £179,147 that was received by the husband by way of inheritance. He did receive it during the course of the marriage in 2015, and it was absorbed into his savings. But the fact that it had gone into an account in his sole name, and the court found that the intention was to invest it further in his sole name, it was accordingly ring-fenced. The court also excluded cash bonuses and restricted stock units that the husband had received post-separation, and also adopted the husband's approach in respect of pensions, in which he ring-fenced the pre-marital pension provision, bringing both parties' pension into broadly equal provision. The court did not exclude, despite the husband's argument, the proceeds of sale from a flat that he had owned before the parties met, on the basis that on the evidence before the court, that asset had been matrimonialised, which is a word we will return to, and also declined to exclude the savings that had accrued from the husband's salary including the salary post-separation, on the basis that those savings had been used post-separation to meet family expenses, and that to unilaterally change that would be unfair on the wife. I pause here just to note a few other issues of interest that arise from this judgment. It's a broad judgment covering many of the topics that we encounter on a day-to-day basis. One of the questions often for us is when the period of post-separation accrual comes to an end, or when it starts. The counsel for the wife, in this case, unsurprisingly, argued that there was no sort of meaningful post-separation accrual, relying on the decision of Mr. Justice Mostyn and in E&L, saying that unless there's been an unreasonable delay between the parties separating and the matter coming to trial, then really for the purposes of calculation of the equest, that should be the date of trial. And the husband, again, unsurprisingly, inviting the court to rely on the decision of Mrs. Justice Roberts in C&C, said really that where there is clear income and assets, identifiable investments arising from post-separation income, then they ought to be excluded. His Honour Judge Hess said that the two arguments were not necessarily incompatible, a bit of a judicial fudge. He said that really, whilst the period of matrimonial equest may end as soon as there is a clear end to the relationship, the court must also take a step back to consider whether applying that principle would result in unfairness. Another point here, as a warning to all of us, is that despite it being a final hearing, the judge declined to deal with the dispute over chattels, effectively pushing it off for further litigation in the absence of agreement, which is something for us to bear in mind when grappling with the contents of the former matrimonial home. Both parties sought costs for reasons, again, that will be all too familiar for many of you. The husband's case was that the wife's suspicious approach had caused him significant expense to respond to, ultimately unnecessarily, as she did concede several of the issues, and he sought reimbursement of just over £115,000. The wife in turn sought an add back for the difference between her legal fees, which were significantly lower than the husband's legal fees. And again, the court had sympathy with her position, in that it's quite often the case where one person spends more than another, and yet both parties' costs are effectively taken into account prior to the assets being distributed. However, His Honour Judge Hess did not think that this was an obvious case for blaming either party, and no order for costs was made. Now, these observations are not citable, being the decision of the lower court. However, at paragraph 57 of the judgment, we have this: with the approval of PLJ, and in relation to the matters discussed in paragraph 52, I certify that the judgment may be cited in accordance with the relevant authorities. And as we know from the President's guidance earlier this year, a judgment that contains such an express statement that the judge intends the judgment to be citable can be made subject to the approval of the appropriate judge, and in circumstances where new ground has been broken. So what is this new ground? In this case, the parties provided not just broadly equal care for the children, but precisely equal care, as is reflected at paragraph 8 of the judgment. The wife nonetheless sought an order for child periodical payments of £15,000 and an order that the husband pay the school fees. The husband said that the court did not have jurisdiction to make a child periodical payments order and that the school fees ought to be shared. His Honour Judge Hess therefore had cause to consider the court's jurisdiction in such circumstances, and this was his approach. Under Section 23(1)(d) of the Matrimonial Causes Act, the court has the power to make a child periodical payments order, and there is nothing in the Act to suggest that payments ought to be made from the parent with less care to the parent with more care, or that payments cannot be made in circumstances where the care is shared equally. The court's powers are, however, circumscribed by Sections 8, subsection 1 and subsection 3 of the Child Support Act, the combined effect of which prevents a court from making a child periodical payments order where the CMS has jurisdiction, save in certain circumstances. And we know that, for example, that could include where one of the parties or the child are habitually resident outside of the UK. And of course, the court can make a top-up order where the CMS has made a maximum income assessment. What is less commonly used, though, is Regulation 50 of the Child Support Maintenance Calculation Regs, which, and the sections here highlighted, in fact provide that where the non-resident parent provides a home for the child and does so to no lesser extent than the applicant, then they shall not be treated as a non-resident parent, and the case is to be treated as a special case for the purposes of the 1991 Act. So essentially, if the care provided by the parties is equal, there is no non-resident parent, and therefore there's no qualifying child for the purposes of Section 3 of the 1991 Act, and the CMS cannot carry out an assessment. And as Honour Judge Hess held that in such circumstances, the CMS does not have jurisdiction. Further, a party does not have to first obtain confirmation from the CMS that it does not have jurisdiction. They can, in fact, apply straight to court, and either party, in such circumstances, can make that application. Unfortunately, in this case, the court was satisfied that both parties had sufficient capital and income, so no order for child periodical payments was made. Therefore, the approach to quantum remains unclear. I suspect that James and Seymour will probably be the first port of call. Moving on to some Court of Appeal decisions, we have Entwistle and Helliwell here. The facts, very simply, the parties were married in July 2019, they separated 3 years later. On their wedding day, they signed an essential, what was termed a drop hands, prenup. Each of them would retain the assets they brought into the marriage. The jointly owned assets, as they were, would be split 50-50 with a clean break thereafter. The parties' assets were disclosed in annexes to that prenup, the husband disclosing assets in the region of £1 million and the wife disclosing assets in the region of £18 million. As it transpired at separation, the wife's undisclosed assets amounted to a further £47 million, bringing her assets closer to £70 million in total. The matter came for final hearing before Mr. Justice Francis in March 2024. He upheld the agreement, finding that the husband knew that the wife was very wealthy and he had taken advice, but he did in fact award him an additional £400,000 on a needs basis. The husband appealed both the judge's decision to uphold the agreement and also the subsequent assessment of his needs. Lady Justice King, sitting with Lord Justices Moreland and Snowdon, allowed his appeal. The usual approach per Radmacher applied, as set out here, and in this instance, the court focused on whether the wife's behaviour was fraudulent, and they noted that, almost counterintuitively, in my view, disclosure of assets is not a legal requirement in order for there to be a binding agreement. However, if the parties to a prenup agree that disclosure should be provided, and then there is either deliberate non-disclosure or deliberate misrepresentation, then the court must consider whether that vitiates or negates the agreement. And in this case, the recitals to that agreement stated that both parties had fully and frankly disclosed their financial resources and that disclosure was substantially complete in all material respects. Clearly, in respect of the wife, that was not the case. And the Court of Appeal said that the wife's deliberate decision not to disclose the relevant assets was fraudulent. Having established fraud, the burden then, of course, shifted to the wife to prove that her deceit was immaterial. In other words, that the husband, had he known otherwise, would still have signed the agreement in those terms. And the court held that she had failed to discharge that burden, and that had Francis J. undertaken the correct exercise at stage 1 of the Radmacher's two-stage test, he would inevitably have concluded that the deliberate decision by the wife not to disclose her business assets and her interest in her mother's house amounted to fraudulent non-disclosure, which vitiates the agreement. However, 8th of August, Sir Nicholas Mostyn published a piece in the Financial Remedies Journal expressing his unease at the Court of Appeal's findings of fraud. And here we have a month later, on the 11th of September, an application for permission to appeal has been lodged with the Supreme Court. So watch this space and watch out for another brunch on this topic. Moving, however, for the time being, to the gift that keeps on giving, we have Pontanina and Pontanin number 2, or number 39, as is probably more accurately deemed. These parties have generated what one judge has said called a blizzard of litigation. There have been proceedings in the Russian courts, appealed to the very highest level, proceedings in the USA and Cyprus, before the wife then turned her attention to the English courts. The proceedings here, I should say, so far have concerned her application for leave to apply for a financial order under Part 3 of the 1984 Act. We have not yet even reached the substantive stage of her application. In January 2019, Justice Cohen granted leave on an ex parte basis. In November 2019, at the return hearing, he had a change of heart. He allowed the husband's application to set aside that original grant of leave, and he dismissed the wife's renewed application for leave. The wife appealed, and in January 2021, the Court of Appeal allowed the wife's appeal against the set-aside and did not, therefore, need to proceed to consider her other appeal against the dismissal of her renewed application. In November 2023, the husband successfully appealed that decision to the Supreme Court, who effectively reinstated Mr. Justice Cohen's decision of November 2019, reinstating that set-aside order, but then needed to remit the wife's further appeal back to the Court of Appeal. Are you still with me? If you are still with me, that brings us to where we are here, which is the matter that came before Lord Justices Moylan, Fulk and Cobb, who focused on the test for leave applications and specifically whether Mr. Justice Cohen was wrong to refuse the wife's application for leave insofar as it related to an application for maintenance. What's referred to as the threshold test, it's set out at Section 13 of the 1984 Act. It's interpreted by the Supreme Court in the case of Agbaje. And Section 13 states that the court shall not grant leave unless the court considers that there are substantial grounds for the making of such an application for such an order. And in considering whether there are substantial grounds, the court will have regard to a theoretically unlimited number of factors, but these ought to include Section 15, which sets out 3 jurisdictional heads under which the application can be brought. That is to be assessed at the date of the application, and also Section 16 of the Act, which sets out a non-exhaustive checklist that the court should have regard to, and that ought to be assessed at the date of the hearing. I haven't set out Section 16.2 here. You can look them up. It includes, for example, the connection that the parties have with the England and Wales, or indeed any other country, if any other order has been made in another jurisdiction, or what rights the applicant has to seek financial relief in another jurisdiction. Now, on an analysis of the evidence, the Court of Appeal found that Mr. Justice Cohen had misapplied the Section 16.2 factors. They allowed the wife's appeal, they proceeded to grant her leave, and then they remitted her substantive application to the Family Division of the High Court. And I suspect that is not the last we've heard from these parties. However, until we hear further, moving on to Standish and Standish, I cannot, of course, do a case law update without touching on this case, although I'm sure you know it well by now. The facts are well known. Husband was 72, wife was 57, second marriage for the parties of 20 years, and 15 years, sorry, ended in 2020. The assets at trial in total in the region of 112 million, and this included the source of contention, what was deemed the 2017 assets, which were investment funds in the region of 80 million that had been transferred by the husband to the wife in order to negate a potential tax liability. The intention of the husband was to place those funds in trust for the benefit of the party's children, However, at the time of trial, the assets remained in the wife's sole name. At first instance, Mordre considered that the assets in their entirety, including the 2017 assets, were all matrimonial property, and he awarded the wife £45 million, which was 34%, the departure from equality reflecting the unilateral source of some of those assets. Both parties appealed to the Court of Appeal, which held that the judge, Mr. Justice Moore, had placed too much weight on the fact of the transfer, too much weight on the title, and in fact it was the source of the funds that was determinative, and that 75% of those 2017 assets were non-matrimonial property. And on this approach, the matrimonial property was reduced to just over 50 million. And if one were to apply the sharing principle, the wife ought to receive in the region of 25 million. The wife appealed again. The matter was heard on the 30th of April, 1st of May. Judgment was handed down on the 2nd of July by Lord Burrows and Lord Stevens. The Lord Reed, Lord Lloyd Jones, and Lady Simpler agreed with the judgment, and the Supreme Court held there's a conceptual distinction between non-matrimonial property, which is typically premarital property brought into the marriage or acquired by way of gift or inheritance, and matrimonial property, which will comprise of the fruits of the marriage, reflecting the marriage partnership and common endeavour. Which party has the legal title is not determinative. The sharing principle applies only to matrimonial property, and the starting point is that matrimonial property should be shared on an equal basis. What starts as non-matrimonial property may become matrimonial property through the process of matrimonialisation, which of course raises the question, what is matrimonialisation other than hard to say and a bugbear with Microsoft Word spell check? However, it is neither a narrow nor an expansive concept. Lord Justice Moylan in the Court of Appeal had said it was a narrow concept. The Supreme Court disagreed. They said it's a question of fact. Has the transformation occurred? Matrimonialisation rests on the parties over time, treating the asset as shared. Over time is a period of time that is sufficiently long for the parties' treatment of that asset to be regarded as settled. And treating the asset as shared can be determined with reference to how the parties manage their finances, and there needs to be an acceptance by the contributor that the asset should be treated as matrimonial property. Finally, and slightly controversially in my view, the Supreme Court went on to say that a transfer of an asset between spouses in a scheme designed to save tax, irrespective of the time period involved, will not normally show that the asset has been treated as shared. Now, of course, they have caveated that by saying will not normally show. However, for them to say that in the first place, in my view, may lead to some further litigation to be considered on another day. In any event, the wife's appeal was dismissed, and the Court of decision was upheld. The final words of the Supreme Court are probably those which the majority of us will use the most, which is that in this judgment, we have thought it important to clarify that the sharing principle, as opposed to the needs and compensation principles, does not apply to non-matrimonial property. And of course, the point that most practitioners find themselves in is that an application of the sharing principle to matrimonial property will not meet their clients' needs, and that these distinctions are somewhat academic. The case of Awolowo, also in the Court of Appeal, rattling through the facts, the parties were Nigerian nationals. The only asset of significance was the former matrimonial home held in the husband's sole name. Net equity was 1.8 million, 1.6 million of which the husband said was held on trust to a third party. The third party was in fact his brother's business, on account of a loan that the husband said he took out to buy the home in the first place. That loan, the husband and his brother had registered with the High Court in Nigeria, and that judgment was then registered with the English High Court. And the brother then sought a charging order in the English court when the husband said that he could no longer repay the loan pursuant to the terms. The matter came before Her Honour Judge Vincent in September 2023. The decision about the charging order had been effectively consolidated with the wife's application under the 1984 Act for financial provision. Her Honour Judge Vincent said that there were reasonable grounds for suspicion in respect of this loan because the wife's case was that it was a sham. but that the wife had not proven that it was a sham, and so she dismissed the wife's application. The wife appealed, and the Court of Appeal allowed the wife's appeal. And what's relevant here, I've set it out on this slide, is the Court of Appeal's view that the judge had adopted the wrong approach to establishing a sham. There is a gloss, if that's the right word, that Mr. Justice Mostyn had applied in the case of Burr and Burris, saying that whilst the test, which is the balance of probabilities, is a stiff one, there is a requirement of very clear evidence. Whereas in the Bank St. Petersburg, it is said that the test in establishing sham is simply the balance of probabilities. And had Her Honour Judge Vincent applied that test, and had she given sort of proper consideration to the facts, because they found, in fact, that she had erred in law and in fact, then she would have not found as she did, and the case was remitted for further hearing. We've got now a probably more pragmatic case here that came before Mr. Justice Peel, the case of BC and BC on the wife's application to exclude or redact certain words from the husband's open proposal that had been included by his solicitors. This was in a letter that was sent 2 days after the parties had, or I don't know, so it was after the parties had concluded a 2-day private FDR. In fact, we can see that they sent it the day after. The disputed words are in bold on the screen, and they make reference to the fact that after the indication had been received, the wife had left the building without entering into further negotiation. The wife said that those words in bold breached the private FDR privilege, and that it was the husband's intention to prejudice the trial judge. The husband's solicitors had refused to file an amended open offer, saying that the words in bold referred to logistical matters, and that if the wife suffers prejudice as a result of her own decision, then the blame for that cannot be at the husband's door. Mr. Justice Peel readily accepted that, of course, there are basic factual details in respect of a private FDR or an FDR that are disclosable, whether or not it took place, whether the parties attended, the identity of the evaluator, the location, the length of the FDR. Paragraph 8, however, of the Financial Remedies Court Primary Principles, which was written by Mr. Justice Mostyn and His Honour Judge Hess, states, and this is at the bottom of the paragraph on your screen, that the court is also entitled to know that there was an assurance that offers were made on each side and an indication given. This, says Mr. Justice Peel, goes too far. The primary principles do not override the rules and the practice directions, which are more restrictive in terms of what can be disclosed. There's no citable case law to suggest that those two matters can be disclosed. And in fact, to refer to whether or not offers were made and an indication given does intrude upon the content of the process, and it risks undermining it, which could lead to ancillary disputes. He goes on to say, I am told that there is or may be a practice developing of parties attending a court after hearing the private FDR, one blaming the other for it coming to an end, in particular asserting that it came to an end where the other party left after the indication without further negotiating. And if there is such a practice, in my view, it should cease. And of course, those words would apply equally to standard FDRs held at court and not just private FDRs. And I'm sure whilst none of you would have taken this approach in your open correspondence, this is now a useful case to cite when your counterparts do. Finally, 2 cases from the lower courts, not citable, but very useful guidance for our day-to-day cases. Here are 2 of my recent favourites. The decision of Deputy District Judge Hodgson in the case of TYB and Carr. The parties separated in 2020. In August 2022, the husband is recorded as accepting an income of £60,000 a month. In September 2022, the following month, Form A was filed, and he said that there had been a significant dramatic change to circumstances and a downturn in his income. He then failed to comply with the standard directions for disclosure, did not file his Form E, did not then proceed to comply with further directions. There was a final hearing listed in December 2023 that was adjourned. It was ineffective on account of his non-disclosure. He was given one final chance to comply, but he didn't. So when the matter then came before Deputy District Judge Hodgson, he proceeded. He found that as the husband had failed to evidence this change in circumstances, then the court was entitled to proceed on the evidence that it had before him and on the basis that there had not been any change. So the court adjourned the wife's capital claim for a period of 10 years as there were no discernible capital assets. But given the husband's previous evidence as to his income, made an award for maintenance for £5,500 a month. And this is a very useful case. It's a good primer on the court's approach in cases of adverse inferences and non-disclosure, which we encounter all too readily. Finally, the case of BY&GC before Mr. Nicholas Allen, case C. The parties had jointly instructed PwC to value their respective business interests. The court already had before it the experts' reports totaling, I think it was about 350 pages, another 60 pages or so of response to the parties' questions. After a private FDR, the husband instructed a new expert who valued the husband's businesses significantly lower. So unsurprisingly, he made an application, a Daniels Walker application, for permission to rely on this second expert. The wife opposed it on various grounds, including that the application was made too close to the final hearing, and that the second expert had seen documents that PwC, the first expert, had not. There's then a very helpful review, again, as a go-to of the law and procedure on both obtaining a second expert's report and then permission to rely on that. The judge rejected the wife's argument that it was delayed, and also rejected her argument that it was fanciful. He said that it wasn't a fanciful reason of the husband in wanting to challenge, but concluded that it was not necessary to allow this. And again, quite usefully for us, he says it's not necessary because the valuation is a broad exercise, generally speaking. There's not a need for mathematical accuracy. It is, of course, the court that values, that determines the final value. There needs to be an equality of arms. If the husband's application were granted, it may encourage the wife to make her own application, and then the risk of delay increases. And what the judge did, quite sensibly, was instead allow PwC to see the documents that the second expert had seen and directed to provide an updated value as to their an updated report, sorry, as to their methodology. And so there we have it, just about in time. We're at midday. I'll take you back to Matiss if he's got time to answer one question. If you need to leave us, then thank you very much for joining us so far. And as I said, the PowerPoints will be available in due course. Thank you.
Thanks, Esther. Thanks for that. She's effectively asking about the effectiveness of the European Court of Human Rights, ECHR, and its applicability in human rights. I think there's something important to note here, that the UK, since bringing the Human Rights Act and so the ECHR rights into domestic legislation, is now one of the least litigated countries that is covered by the ECHR. It's did find some stats on it. I think since 1975, the UK accounts for about 1.4% of decisions where a violation has been found, and that's out of some, I think, 22,000 cases. And currently, the UK, I think, is now the lowest country for cases in respect to it. I think it's down like 0.19, or I think it's 1. You'll find different stats, but it's between 0.4 and 0.19% of the cases the ECHR deals with. And my understanding is the cases that are open, they are very complex technical points made in respect to procedures, generally within criminal law, and there's also the ongoing immigration matters dealt with. So what the Human Rights Act has done is reduce the number of matters dealt with by the ECHR, I think by comparison, whereas the UK sits at, I think, 0.1% of cases, Italy sits at 11% of cases. So depending how you define effectiveness, it does seem to have had a significant impact in compliance with human rights. But thank you all. That's the only thing I think I'll deal with because we're right pressed against time. I'll hand that back to Esther if she wants to deal with any questions.
Thank you, Matiss. Yeah, we've had a few coming through. We will endeavour to answer them in due course. We can contact you directly. I've had one that's just come through in respect of child maintenance. Question about where, as again is often the case, the client practically has equal care for the child, but not exactly equal. In those circumstances, the CMS are still able to carry out an assessment of the non-resident parent's income because there is still, per the regs, a non-resident parent. What they do is then apply a reduction, depending on, as you will know, on how many nights the child spends with your client. The maximum reduction they can apply is 50%, and that's in circumstances where a child spends 175 nights or more in the non-resident parent's care. Now, given that 50-50 is 182 nights, and in those circumstances the CMS does not have jurisdiction, it may seem unfair that for that sort of bracket essentially of 7 nights, a payer is still liable and is still liable with only a 50% reduction to what the assessment would otherwise be. But there we have it, and that seems to be very clear on any reading of the statute and the regulations. I think the only thing I would note, and of course, sort of child maintenance is not my expertise. It is subject to a whole sort of separate area, but I do note from the regs that what it says is that a person provides day-to-day care to a lesser extent, and as I understand it, there are tribunal decisions as to what that day-to-day care actually entails. It's not certainly on paper purely restricted to a qualitative element. There must also a quantitative element. There's also a qualitative element of what that day-to-day care means. I think the other point I just note is actually subsection 3 of Regulation 50, which says that where an applicant is receiving child benefit in respect of the child, then it's assumed in the absence of evidence to the contrary that they are the person who's providing day-to-day care to the greater extent. And of course, sometimes arguments between parties as to who should receive child benefit can seem somewhat petty or minor given the sums involved. But it's reminding you to have regard that in certain circumstances and absence evidence to the contrary, the fact of the receipt of the child benefit is something that a tribunal would take into account and place some weight on. So that hopefully answers, or may not, the question. I'm happy to give that further thought, but we are out of time. So just to say thank you very much again for attending, and to reiterate, our next brunch is on the 27th of November. Before that, we have our 3PB Public Law Care Conference. That's on the 21st of October. It's an in-person attended event in Southampton. A link will be posted in the chat box to that. And of course, please don't hesitate to contact us or the marketing team if you have any further questions. Thank you very much and have a good rest of your day.